Hello, everyone, and welcome to the presentation CalPERS Circular Letter 200-01423 regarding disability retirement and reevaluation required documents. As you know, CalPERS put out this circular letter, and many of our CalPERS member clients have been asking questions about what it means and what the new requirements are for them, because it does lay out many different requirements that the agencies must now follow. This presentation is being brought to you by RTGR Law. And we have Patrick Thatcher, who is here to present here today. Next slide, please. So Patrick Thatcher is a supervising attorney here at RTGR Law. He has a plethora of experience working as a workers' compensation defense attorney, and he's the perfect person to be speaking here today because he has years of practice working with municipalities, public agencies. He works in all aspects of workers' compensation defense and works with a lot of clients who are members of the California Public Employee Retirement Law System, CalPERS as we know it, but also the County Employee Retirement Law System, also known as the 1937 Act. He also has experience with reconsideration of agencies' decisions under the California Administrative Procedures Act. He obviously has experience before the WCAB, but also the California Office of Administrative Hearings. I've personally worked with Pat for many years, and I can confidently say that he is well-versed in this area. And this topic is one that he will be able to provide you with good information on because he, works with clients every day regarding CalPERS requirements and overlap between workers' compensation. So let's get right into it. The CalPERS Circular Letter. And maybe I should introduce myself, Lauren Zalona. I'm a partner here at RTGR, and both of our emails were on the prior slide. If you would like to send us email, thank you. We also will give you some of our information at the end of the presentation if you have questions. But yeah, okay, let's get into it. So Pat, take it away, please.
Hi, yeah. So just before we jump in, there's a quick disclaimer, which is basically that this is for educational and informational purposes only. It is an abbreviated overview and should not be construed as legal advice on any subject matter, nor as a substitute for quality legal services. And it's copyrighted by RTGR, and all rights are reserved. So yes, jumping right in, this circular letter provided, new procedural requirements for processing applications for industrial disability retirement as well as disability retirement. CalPERS listed the scope as directed to all contracting agencies with local safety members. So, essentially, if you have police and firefighters and your city is covered by CalPERS, then this is highly relevant to you. So yes, jumping right in. Sure, we're all very excited for this. Come on, next slide. There appears to be a brief lag on getting this to switch slides. There we go. So I started this with a quick comment on the reasons and authority that CalPERS listed in the letter. I thought that was a little revealing. So it's cited to government code sections 21232 and 21233. And both of those deal with post-retirement employment. So if someone's working after an industrial disability retirement, there's certain rules about what kinds of jobs they can do. If they're still working for a CalPERS covered entity, there's certain rules about whether they have to be reinstated, all sorts of things like this. So that was one of the things they're looking at. And also just in terms of if they're not covered working for a CalPERS covered entity, if they're doing the same job they were doing prior to their retirement, but for, a county or the federal government, That's obviously something CalPERS might be looking at to see if their incapacity needs to be reevaluated. They're also looking at, whether or not these are competent medical opinions. So that would be Government Code Section 21156. So I think one of the things CalPERS is going to be looking at is, are these medical reports that we're providing, backed up by the record? So they make a big deal about having the diagnostics that the doctors are relying on, having all the information that the doctor was looking at. So I don't know if this is, CalPERS kind of tipping their cards a little bit, or just saying, look, we're going to be looking a little more closely at, whether this is competent medical evidence or not, or whether I'll say the city's determination as to disability and incapacity is based on competent medical evidence. And just for those that are more used to workers' compensation, competent medical evidence is similar to what you would call, reasonable medical probability. I would say the standard for competent medical evidence is even lower than reasonable medical probability, arguably. But I think CalPERS can look at a report and say, look, this is just not competent medical evidence. It's, not based on objective findings. So you need to, supplement the record with additional information, or, we're not going to approve it as is. That's one of the things that I think maybe CalPERS might start looking at more closely. But this is 100% me just reading the tea leaves. It's not really based on anything. And then again here, CalPERS' authority, they cite to their, authority to look at, or obtain information that might be necessary to the administration of benefits that they might be liable for. So I'm sure if you're a local, work at a local city, CalPERS has probably been pushing you to perform re-examinations of disability retirements when people are turning 50 or right before that point. And that's because that's when CalPERS becomes liable for those, or financially liable for those, or financially responsible for those retirement benefits. Before 50 years old, in general, it's kind of complicated, but the city tends to be financially responsible. And then after 50, that burden shifts to CalPERS, which is why they want you to re-examine people. So I think that also then speaks to, what are they doing? What is the person doing for work after their retirement? Are they, do we have enough information to re-examine them? All of those kinds of factors. But yes, I just wanted to start with that because I think it's a little revealing in terms of why they're asking for this information. So next, these are the various forms and information that the CalPERS is now asking for. So it's basically the physical requirements of the position. This is the new form that you'll have to fill out. A job duty statement that's generally, I think what's provided like on the likely, a public record as to what are the job duties, qualifications, physical requirements that's likely already maintained by the city. Then a new form that's a physician's report on disability. So the physician actually stating, are you disabled or are you incapacitated or not? Then there are all of the medical records and reports that are relied upon by the physician and the city in making their determination. And then there's the workers' compensation carrier request. They use carrier here, or specifically actually insurance carrier. I think what they really mean is TPA. I don't think, most of the agencies are self-insured. So I think they really mean TPA here. But going forward, I'm going to go through each one of these forms in a little bit of detail and try to provide some practical advice and just notes on each one and things to look out for each one. So the first form is the physical requirements of the position. So, the usual job duties that the person's doing. Hopefully your agency should have an essential job functions analysis for the purposes of FEHA that's been negotiated with the union and is, everybody agrees to. And I would use that to fill out this form. That would be my advice. So each time one of these comes up, sit down, fill this out based on the EFJA. And then the next thing you would do is schedule a meeting with applicant or the potential retiree, because the retiree then has to sign this. And one of the key things here that I think is going to come up, it's hard to say because I don't know yet, but the signature is not necessarily an agreement to what's in the form. So if the person says, I don't agree with what's in this form, these aren't my job duties. These things are not physically required by my job, or my job is more physical than this. You're saying I only have to lift 50 pounds. I routinely am lifting, 150 pounds, something like that. Just because they're signing, they're not agreeing with it. The form specifically says, if you disagree, you can provide comments, you can attach your own, they can write a letter, they can do whatever they want. And the key thing here is that, another key thing is that in addition to them, they don't necessarily have to agree, is that the original copy of the form goes to CalPERS. I don't know if there'll be sticklers about that, but then applicant gets a copy and a copy goes to the evaluating physician. Just given my experience in dealing with some of these, sometimes people can be a little difficult in just participating in the process. And so if they're just refusing to sign, I would just send an unsigned copy and just note in there somewhere, either in a letter or write it directly on the form, member declined to sign, something like that, just to keep the ball rolling on the retirement process. Because in general, usually the sooner they're retired, it's better for both parties. But I'm not saying people are going to be difficult, but in the event they are and they refuse to sign, I would just go ahead and send that to the doctor unsigned. The next slide, once it decides to move, is the job duty statement. I put this up here essentially just to note that the job duty statement is different than the physical requirements. As I said earlier, essentially the job duty statement might have all of the information that the physical requirements asks for. And so you might think, this feels a little repetitive. All of this is already provided. I can just send it in a different format. And while I would say, that's practically, the same thing, and I totally understand what you're saying, I would just, throw CalPERS a bone, not swim upstream, and just fill out the form and still send it to the doctor. If you're a TPA and you're gathering information and you need to send it to the QME, I've often been able to find these job duty statements just on city websites. They're usually posted. So you can confirm maybe with the city that that's the correct one, or you can, just find it on the website and send the doctor something to look at. And so before I get into the medical report, I just wanted to touch a little bit on who the examining physician is, and then what constitutes a competent medical opinion. So I just get questions about this a lot, so I just wanted to touch on it. An examining physician can be the QME, it can be the agreed medical evaluator, and it can also be an independent medical evaluator, or even the treating physician. There's no legal requirement that it be any one of those doctors. Sometimes I get a question that's along the lines of, well, we've always used an IME, or we've always used the QME for this. And my answer is, well, there's no requirement to do so. If you have an established practice, maybe you want to talk to a labor practices attorney about whether you can just change that practice or not. I would defer to them on that. But in terms of legal requirements, there's no legal requirement that it be one doctor or the other. It just has to be competent. One thing that I think is maybe underutilized is the IME. If you're in a situation where you just can't get the reporting that you need from a QME or in the PTP, the primary treating physician, and not I don't mean substantively, I mean they're just not answering your questions, they're not doing a good job. Maybe you have a chiropractor or just a really difficult QME. I've had this come up with psych claims, for instance, where you just can't get a straight answer out of them. So what I've done in those situations is assign an IME. And the nice thing about that is that the employer can choose what doctor it is. And the injured worker is required to show up. I generally like to take a collaborative approach with these retirement processes. So often I'll negotiate this with the other attorney. I'll say, look, let's do an IME. It'll only be admissible for the retirement proceedings. And we'll just use this doctor that actually knows what they're doing. And you can keep your hack for, the purposes of disability and apportionment. And oftentimes that can get you past, over the hump, get the retirement done, and just help move everything forward. And then you go back to the psych doctors, the workers' compensation doctors for the rest of the workers' compensation claim. So that's just another practical tip for, kind of getting the medical reporting that you need for the retirement. And that just comes from sometimes workers' compensation doctors, they're not familiar with, what actually needs to happen for IDRs. That's often why I use specific AMEs in cases, just because they actually know what we're looking for, so they can provide the reporting that we need. But sometimes that doesn't always happen. And then in terms of competent medical opinion, CalPERS likes to point out that it needs to be a specialist. So sometimes I've never actually had this come up, but I always thought if there's a chiropractic panel, whether or not that chiropractor can provide competent medical opinion, even though they're theoretically qualified to be a QME, that's a situation that I would also consider an IME. But in general, if you read through the case law about competent medical opinion, a few of the points that often come up are that incapacity is the substantial inability to perform usual and customary duties. I love when they use a confusing term and then define it with more confusing terms, but that's generally what they say. And the incapacity has to be objective. So if you look at the physician's form that CalPERS is asking for, they're clearly looking for diagnostic evidence, which we can get into what's objective versus subjective evidence, but there needs to be some objective element to it. I find that particularly interesting for PTSD cases, because what's objective about a PTSD case. But mere discomfort rendering performance of duties difficult is not sufficient. So if the doctor's just saying, well, they can do it, but it's going to be uncomfortable, that wouldn't be enough. They would need to say they actually cannot do the activity. So, if you get a report that says something along the lines of, it would just be very uncomfortable for them to, do that much bending and lifting, you need them to actually clarify that the injured worker cannot do that activity. Also, prophylactic restrictions intended to prevent the risk of future injury or harm are insufficient. So basically, if the injured worker is just, likely to re-injure a knee, or they're likely to re-injure their back if they keep doing these activities, that would not traditionally be enough. It would have to be that they can't actually do the activity. I think there's a line to be drawn there between something that's just unsafe for them to do because of their injury. So somebody who has a back injury that's, at risk of sudden and total incapacitation really shouldn't be working as a police officer or a firefighter, or in an emergency situation. And even though that's, a risk of future injury, it's not necessarily there. I would say that isn't prophylactic. So sometimes it can be a little, that one I think is a little complex, but that's something you can work through as it comes up. Yeah, so I just wanted to touch on those things because these are two topics that I get a lot of questions about day to day. Yeah, so the next one is the physician's report on disability. So this is the form that the physician will actually sign. If you're using a QME or an AME or even a PTP, I would likely send a letter that provides some instructions on filling this out in addition to the form itself. I think that can just help, the doctor do it. I have a note later on in the presentation, I know, but this is a point where I like to just remind cities that There are ex parte rules for how you communicate with an AME or a QME. So just be careful if you're going through as you're going through the interactive process to be wary of those. For instance, like a treating doctor, you can just send whatever you want to that treating doctor whenever you want. But for an AME or a QME, to send new information, there are specific rules about how you do with that. So just be sure to, coordinate with your adjuster, with your TPA, and how that information is going to be conveyed, to make sure you're not running afoul of any of those AME or QME rules. So yeah, the form answers basic questions. Is the injured worker substantially incapacitated for the performance of essential functions? Is the incapacity permanent or likely to last for 12 months? I believe that's 12 months from the date that, the evaluation is performed. And are they permanent and stationary? Another practical thing here is that the person does not actually need, in my opinion, need to be permanent and stationary to have a finding that they're not going to return to work. And my favorite example of this is someone who's like a quadriplegic, obviously that person is not going to be returning to work as a firefighter. But they might require additional care to, increase their quality of life, or just, be able to get through their day. And so they're not permanent and stationary, but it's very obvious they're not going back to work. Same could be said of somebody that's having a really intensive, back surgery. It's so unlikely that they're going to be returning to work. Sometimes you can get that IDR done, maybe negotiate a buyout with the other side, something like that. So you can, get them off the books and process their IDR before, you have that permanent and stationary finding. And this is actually another time that I've used IMEs, because the QME is insisting, oh, well, they're not permanent and stationary, and so I'm not going to comment on their ability to return to work yet. They're just flat out refuse to do it. And in that scenario, that's another time where I've looked to just another doctor that will say what we need them to say, and often the other party will agree with us to go to that doctor to get the disability retirement processed.
And Pat, I just want to say, I think this is an important point too, because a lot of our, agencies, sometimes people don't recognize that even in a workers' compensation claim, right? Like you said, that someone may not be permanent and stationary for purposes of rating or a final report, but that we can sometimes on a parallel track be, handling this return to work issue separately, right? And, sometimes the applicants' attorneys we work with that may not do safety stuff often don't really know, they don't understand why we're harping on this issue. But that's why sometimes it's, can be good to have defense attorneys that are familiar with this, so we can take these parallel tracks, knowing that the return to work issue can become relevant before a PNS report is issued, right? And sometimes the QME or the AME may say, deferred, or okay, they have these restrictions, right? But CalPERS requirements are usually within a 12-month span, right? So we can write to a doctor and say, we know they're not PNS, but, here's their job duties, right? A police officer, right? Very intensive job duty requirements, and say, within the next 12 months, do you foresee this person returning to their usual and customary, right? So we can take these parallel tracks together, kind of tied to, like, they're intermingled, yes, but completely. We can do them separately.
Yeah, so I always am looking at it when I receive a case, especially if the person's already 50 years old, so they can retire whenever they want. One of the things, if it looks like you're going to be spending a year 4850 anyways, if you approach the other side and negotiate some sort of buyout, for instance, where you're paying 50% of their 4850 or 4850 that's left on the books in exchange for them retiring a little earlier, that can be advantageous. If they're under 50, maybe they're, in their late 40s, but they're close enough, then that's a scenario where you can maybe negotiate something that works for the city because it gets them off the books. It works for the injured worker because you end up receiving kind of the same amount of money anyways, because half your 4850 rate is essentially theoretically the same as your pension rate, because your pension rate is 50% of your earnings for the prior years, generally speaking. Yeah, so you can often get something done, not always, but in general, applicants' attorneys are remiss to, agree to any type of retirement while the person has 4850 on the books. So that's why I often am talking about these buyouts. Sometimes cities are concerned that it sends the wrong message, things like that, to just be offering too many buyouts. And that's certainly something to take into consideration. But these are just things you can consider. And some of the practical advice that I like to give people in options. Because often the biggest thing I ever hear is it's killing us having somebody off work for this long and being unable to replace them. And now we have shortages in staff. We already had shortages, and now we have somebody not working. We can't replace them. Why is this taking so long? So these are some of the things that I think you can do to make sure this happens quickly. And then one of the importance of being careful with these forms is just then, once you have gone through that whole thing, you have an agreement from the other side, they're going to retire. You don't want your application to be delayed by CalPERS because of paperwork, essentially. So that being said, the diagnosis section here, they are clearly taking a very literal view of objective medical evidence. They want you to, lay out diagnosis 1, the objective findings. Again, for PTSD, I don't know what's considered objective, but maybe test results, things of that nature. What diagnostic tests they're relying on, and then what specific restrictions and limitations. So here, I think it's a little unclear, but I think what they're asking for is, what specific or what limitations do they actually have? So they can't lift more than 25 pounds. They can't run. They can't kneel, squat, or bend, things of that nature. And then later on in the report, I believe they want you to then link, maybe in the same place, link their physical limitations, with direct references to the, for the job duty statement and the physical requirements form that you provided with the, with their actual limitations. I think they want all of that spelled out, or at least I would want all that spelled out if we were sending this information to CalPERS. That would be the best practice. So CalPERS notes on work restrictions. This is directly from the letter. And they are basically saying that you need to be specific. It's not enough to just say the member's unable to do their job, or permanently incapacitated from the performance of their duties. They want it quite granularly spelled out. And I mean, I'll take this as a kind of a change for myself, because I often thought, it's okay if the doctor makes that statement, as long as otherwhere else in the record, it's super obvious that the person is unable to do their job. So if you read the same report, elsewhere in the report, there's work restrictions. If you read their medicals, they've been on modified duty or light duty, or, off work with these restrictions for a year and a half, and they have not changed. Like, that to me is pretty good evidence that, they're not going to all of a sudden turn around and work full duty. So that's something to keep in mind, is that they really want the doctor spelling out exactly what they cannot do and why that prevents them from being able to do their job. Yes, so that's just what I wanted to add there. And yes, so the next kind of practical thing here is the form asks the doctor to provide a copy of everything they looked at, or at least everything they relied on. And I think that's going to cause some confusion, because basically what we're doing here, especially if it's an AME or a QME, is the TBA or the defense attorney sending a bunch of stuff to the doctor to look at. The doctor's going to look at it, fill out a form, and then be presented with this scenario where they then have to send what we just sent them back to us attached to the form. So practically speaking, I think what we need to make sure happens here is that anything that the doctor relies on, especially if they're writing in their diagnostic section, MRI from this date or EMG from this date, or, psychological testing reports from this date, make sure that that makes its way to the city with their physician's report and then to CalPERS, whether that comes from the TPA or the defense attorney or elsewhere or directly from the medical evaluator, that's great. But I'm even going to consider writing on the form, maybe I'll get in trouble for this, but, records to be provided by TPA, something of that nature, or just leave it up to the doctor if they want to attach it. But if they don't, I don't think you necessarily have to waste a supplemental report going back and obtaining information that you sent the doctor to begin with. I would just be really clear that everything that they relied on is, in the packet of information that's going to the city, and then in the packet of information that's going to CalPERS. I think that's what they're looking for. It's kind of, in my opinion, a little, CalPERS being unclear as to how procedurally these things actually play out for local safety agencies. But yeah, I think that's what they're looking for. Again, I have another warning to just be careful of ex parte communications. And then the last thing I want to make sure I mention is sometimes doctors do testing in the office at the QMB exam. So this might be an X-ray, or I know I've seen Dr. Manisha Ryan will do EMGs at her office. And so it's important that if they are doing that testing and they're relying on it, the QMEs actually don't always provide a copy of that testing to you. So sometimes you have to write to them to ask for the specific results. So in this scenario, if that happens, make sure you obtain it. The other place to look out for that is definitely psych. Sometimes if you send them to a psychiatrist, they'll send the injured worker, they'll have a second doctor that's kind of in the background, basically perform a bunch of testing. So they'll send the applicant testing, and then there'll be test results. And if the psychiatrist or psychologist that's doing the actual examination is really on top of it, they'll also provide a copy of that testing. But in a lot of cases, they don't. So I would just make sure that if the doctor is relying on it, or if it's referenced somewhere on the report, just make sure that that's available. And again, then sent to CalPERS, or sent to the city and sent to CalPERS. So yeah, I think that's what CalPERS is looking for here. I think that if the doctor checks no, I didn't provide the report, but I reviewed everything that was sent to me, but I didn't send the stuff to the TPA. I personally don't think that's the end of the world. Just make it clear that everything that was sent to the doctor was eventually provided. And that's something I think you could even put in your determination letter, spelling that out to CalPERS, in my opinion, at least. So the next last form is the workers' compensation carrier request. Again, I think this should just be filled out by the TPA. I don't know why it says insurance carrier. I believe that's a misstatement. But it asks you to identify all claims, quote, directly related to the application for disability, or IDR. I'm sure, as many are aware, that police and firefighters oftentimes have a lot of minor claims, first aid only, things of that nature. You don't need to provide everything to them. It's only what's directly related to the application. So, that retirement claim that you have, or if there's, one open claim and 3 reopened claims, maybe provide all of that. But yeah, I think that makes sense to most people, I'm guessing. The only other really practical thing I could think of when I was looking at this form and just contemplating what might cause issues is it directly asks for all surveillance and all investigation materials, which I think could be tricky if there's surveillance or investigation materials which we haven't disclosed to the other side. and we're, holding close to the chest for litigation. So in that scenario, I think that there's, and again, this is just my thoughts, is that you could draw a line that something's privileged. And so, especially if there's surveillance that we obtained that didn't show anything, and we don't really want to disclose it because it's just going to rock the boat. We followed someone around for 3 weekends in a row. We obtained no information, and it turned out they were doing exactly what they said they were doing. I think in that scenario, it is privileged, especially if you have an attorney and it was obtained at the direction of the attorney, potentially. But also is not being relied on because it didn't show anything. So in that type of scenario, I wouldn't think that you necessarily have to provide it. But, certainly anything that we've made public, so it hasn't been obtained, at the direction of counsel for the purposes of litigation, any witness statements, that initial investigation form, I think that's totally fine to provide if an investigator came out and obtained a witness statement from the injured worker. That's perfectly fine to provide. And I'm not saying don't provide all of the surveillance. I'm just saying that it's worth a discussion if there's a serious, privileged, attorney-client privilege or attorney work product privilege issue. So again, here, didn't request, claim notes or benefit notices or correspondence. I think you can likely withhold that information, not withhold it, but I don't think it's relevant. I don't think you need to send all of your medical notices. It does say further exams scheduled with treating physician. And I thought that was odd because it says exams. And I was just thinking to myself, well, people continue with treatment after retirement all the time. So I don't think it's necessarily, if you have a treatment appointment, you need to disclose that. I think you could, but I would be okay reading that to just read to an actual examination of disability, not necessarily like I'm going in and I'm going to get my re-up of, my prescriptions or I'm going to request an H-wave or, whatever the point of the upcoming treatment is. You could certainly put that in there, but I kind of read that to be like an examination of incapacity for CalPERS. That's my personal view, but if you want to be completely 100% safe, you could certainly put in that they have a treatment appointment upcoming, and you could even write on the form, specifying that as medical treatment, not related to incapacity. Because I think what they're looking for is, just making sure that we have a final sense of disability in incapacity, and that we're not assessing it and then the person's going to improve substantially over the next few months. Yes, so the next one is all medical reports used in the making of the medical determination by the city. So basically here, anything that I think is sent to the examining physician, I would send to the city, and then that can be provided to CalPERS. Just to go back, I think the other kind of complicated one here is subpoenaed medical records. So, oftentimes you get 10,000 pages from CalPERS, and it turns out none of it is relevant to their work injury. So you don't even end up sending it anywhere. You have all these thousands of pages of records, and I don't think that you necessarily need to send that to the city and then to CalPERS if it wasn't actually relied on by the doctor to make the incapacity determination. I think the safest thing would be if you sent it to the examining physician, so the QME, the AME, the IME, or the PCP, the safest thing would be to obviously to provide that. And that's what I would do. But if I have a bunch of subpoenaed records that I didn't send to anyone and I didn't think were relevant because, it's like appendicitis and they have a broken back, like it's probably not going to lead to anything other than a giant bill. That is the kind of thing that I think you could maybe withhold. But the important stuff to make sure is in there is all of the treatment reports. I would include any subpoenaed records that were directly sent to the doctor that's doing the incapacity examination. And then all of the diagnostics that are referenced in the report. So a quality control step would be to take the physician's report, go through anything that's explicitly cited in there, make sure that it's, you can find it in the packet, maybe attach it to the back of that, form so that it's easily, whoever's going through this at CalPERS can easily find that information. And then another stack of documents that's, everything that was sent to the doctor throughout the process of determining incapacity. Yeah, so that's, and then I'll also just for the claims purposes, make sure all the med legal reports are in there, even the ones that are not necessarily laying out the incapacity. So all medical legal reports, deposition transcripts, things of that nature. The things that I would maybe not send are the just thousands of pages of records we didn't even send to the doctors, privileged materials. Like I wouldn't be sending my letters from the defense attorney to CalPERS. That's something that I would definitely be withholding, things of that nature. But if there's specific questions about that kind of thing, we can kind of answer them as they come up. Okay, there we go. Sorry, there's a delay on getting this to change. Getting towards the end here, I promise. I know this has been a riveting presentation. You're all on the edge of your seat. The determination letter is very important. Thankfully, it's covered by another circular letter, so I'm not going to go into tons of detail here. The specific, summary of the specific information that CalPERS is looking for is provided here. Again, it's, determinations based on competent medical evidence. I guess you could state that, but that's really is it. Determination was not used as a substitute for the disciplinary process. So, you got to provide personnel materials under certain circumstances. The member is substantially incapacitated from the performance of their usual duties. That's kind of the most important aspect. Is there a workers' compensation claim? Is the disability industrial? What's the effective date of retirement? Their last date on payroll. Was 80 advanced disability pension payments issued? That's ADPP. Is there subrogation? And then was the disabling condition, or what is the disabling condition? And is it likely to last for at least a year? Last friendly reminders, I promise. The DR, or disability retirement, and industrial disability retirement processes are part of the interactive process and considered reasonable accommodations under the Fair Employment and Housing Act. So as you're going through this process, don't forget that you also need to go through the interactive process. So those work restrictions that you receive from the doctor, you need to actually go through the process to be safe, in my opinion, go through the process of seeing if you can provide an alternative work assignment, if you can accommodate those work restrictions, in order to just be 100% safe under FEHA. I can't think of a single situation where someone went to, work as a receptionist at the records office after working as a police officer instead of retiring. I've never seen that. But it's just safest to go through that and see how to schedule that meeting, document everything. That's where you're going to be the safest. The injured worker, especially if they have counsel, is 100%, able to waive that process. If they waive it, I think it's usually smart to get that in writing. But, be smart about how you're going through the interactive process. Keep FEHA in mind when you're going through this this IDR process. And if necessarily, I would, you can consult with a employment attorney on that if there's real concerns. Also, to just IDRs potentially affect liability for workers' compensation benefits. We touched on that a little earlier. So just keep that in mind. Coordinate closely with your TPA. coordinate closely between the city, know exactly when we're stopping sick leave, exactly when we are cutting TD off, all of these kind of factors. Another thing that I see sometimes is a person's been working light duty, they're then going to be retired. It's probably safest to then start PDAs. So just keep the PDAs in mind, and just make sure that these are all kind of coordinated as you go forward. It can be complicated. So yeah, just something to keep in mind. And then the last is advanced disability pension payments under Labor Code sections 4850.3 and 4850.4. In my opinion, they're mandated under 4850.4, and they're payable within 30 days of the last payment of sick leave, regular wages, and 4850, barring certain scenarios. If the person's not participating in the process, if they are there's evidence of fraud or there's no work injury, things of that nature, but that often doesn't come up too much. But yes, so just make sure that you're paying ADPP, make sure that you're coordinating payment of ADPP with cutting off TD or 4850 or what have you. Yeah, and be careful of the interactive process. I think that's all I have here for my yes. Lastly, thank you if you're still with me, congratulations. You're the one. So yeah, thank you for sitting through that with me. I know it was fairly dry. And if you have any questions, please feel free to reach out to myself or Lauren or any of our other high quality RTGR attorneys.
Thanks. So although I wouldn't necessarily say dry, Pat, but very important, at least, to say the least. So, and if you go ahead and click to the next slide, it'll give some information on what RTGR law does. We have a list of things. This is not inclusive. We do, not only public agency, but obviously this presentation is mostly geared towards that because we're dealing with CalPERS. So RTGR is here to serve public agency clients, and we have many attorneys that are experienced with municipalities, including Pat and myself, who, Pat and myself handle almost exclusively public agency clients. And, as I think Pat and I can both attest to, every municipality has its own unique set of needs and challenges, depending on the size and the amount of employees, or whether there's risk management and HR or both. And so I think having a defense attorney that's experienced with working with public agencies is so important, because we understand that every municipality has different needs and different challenges that it faces. Just like we have here with the CalPERS, right? The circular letters. And so knowing how that overlaps with the workers' compensation cases and the medicals to make sure we're securing the most, cost effective and successful outcome for our clients. Because at the end of the day, we're working with, public funds here. So always trying to have that in the back of our mind. And, we try to work collaboratively with the TPAs, risk managers, HR departments, and the, individual departments to tackle some of the most complex cases. So we have multiple offices in the state. On the next slide, we have the email information for the local offices. If you are in a particular part of the state or have a case at a particular WCAB, we serve all the local WCABs. And then Pat and I also, you can shoot us an email. Each of our emails were at the beginning, but it's basically so Pat is, I think, is it Patrick? I think it's Patrick at rtgrlaw.com. And mine is Lauren Z at rtgrlaw.com. So please feel free to reach out to us if you have any questions. You can visit our website. We have many other on-demand webinars, and we're always adding to that. And you can also follow us on LinkedIn, where we're constantly giving updates when we do have webinars, presentations, or any engagements that we're speaking at. But yes, thank you so much for attending, and hopefully this was informative. Again, if you have any questions, because this is live, we're we're seeing this in real time and trying to figure out how to do this and work with CalPERS to do this. So please feel free to reach out to us if you have any questions. With that said, thank you very much. And I hope you have a great rest of your day or evening or whenever you're watching this. Thank you.